Welcome and thank you for joining today's webinar titled Expanded New York Whistleblower Protections, What Employers Need to Know. All participants are in listen-only mode. You're encouraged to submit questions throughout the presentation using the Q&A feature in WebEx. If your question is not answered during the program, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Howie Wexler. Howie, you may begin.
Thank you very much, and good afternoon, good morning, everyone. We're delighted for all of you to be here with us today to discuss a real sea change for New York employers. For those of us who advise clients in New Jersey or have clients who have operations in New Jersey, you're likely very well aware of New Jersey's Conscientious Employee Protection Act, otherwise known as SEPA. It's well known as being one of the most robust whistleblower protection laws in the country and is a big source of litigation for employers. Well, on October 28th of last year, Governor Kathy Hochul in New York signed legislation which is effective tomorrow. See how the timing worked for our presentation. We wanted to make sure that we at least covered it before the law went into effect. That completely changes the landscape for New York employers when it comes to whistleblower protections, and in many ways mirrors the protections provided by SEPA. It's not uncommon for New Jersey and New York to kind of piggyback on each other for L&E related issues, whether it's misclassification issues or sick leave issues. And this is one of those instances where we have a law going the other way across the Hudson into New York. So we're glad to be with you here today, and we're going to discuss this new law and discuss things that should be on your radar going forward, given the amendments to Section 740 of the labor law, which is New York's whistleblower law. And again, it's really, better viewed as a new law as opposed to an amendment of a current law, because it really bears, and as we'll get through today's presentation, no resemblance to what the law previously was. It's really a brand new law on something for everyone to keep in mind. So with that, can I go to the next slide? Our speakers here today are our esteemed panel. First, Rob Siva. Rob is a partner in our New York office and a key member of our New Jersey practice group. Rob advises clients on a wide range of issues under federal, state, and local law, including background check issues, prevailing wage requirements, wage and hour issues, whistleblower cases, and a whole host of other L&E issues. We also, I'm very happy that we have two of our great associates here in New York presenting with us today that have particular insight, given that both Victoria and Amanda are formerly clerks in New Jersey, both in federal and state court. So they've definitely seen their fair share of SEPA whistleblower issues in New Jersey, and are, we're delighted they could be with us here today to share their insights as well, given that they've really been in the trenches, and listened to and heard from and worked with judges tasked with interpreting a broad whistleblower law like the one that New York is going to have effective tomorrow. So Victoria's practice focuses on single plaintiff litigation, defending employers in cases of discrimination, harassment, retaliation. She also advises clients on separation agreements and wage and hour compliance. And Amanda's practice is in single plaintiff litigation, as well as complex employment litigation surrounding issues of discrimination and unfair wage practices. And I'm Howie Wexler. I'm a partner in our New York office, co-chair of our New Jersey practice group. And again, delighted that you could all be with us today. Next slide, please. Just for a brief rundown of our agenda, welcome and introductions have now been done. We're going to go over the current New York whistleblower law, what it looks like today, and then obviously what it looks like going forward. We have the statute that is now going to go into effect, so we'll discuss that, and some of our experiences based on some of the language in the statute in terms of how courts or administrative agencies may start to view these laws. We're going to touch upon other whistleblower protection laws in New York. There are other ones in addition to 740 of the labor law that we're going to talk about. Go over some of the federal counterparts that many of you are familiar with. And then we're going to try to go over some examples of whistleblower activity just to, get everyone thinking in terms of how this new law is structured and, real world examples of, things that could be considered whistleblower activity and under the guidelines of how the statute's written. And then finally, just, some employer considerations, some right now that might be worth considering, others down the line. So again, we're jam-packed in this hour. So hopefully, we'll make sure to answer, go over our materials, and obviously any questions, we're going to try to, take those throughout, during the presentation, and then get back to everybody afterwards so that we can get through all of our materials. But, don't hesitate to send those questions along, and, we will get back to you after the presentation. Next slide, please. Okay, so, the Whistleblower Section 740 is the statute that exists now, that's being amended, and the highlights that we're going to talk about in terms of, what the law is now versus what it is going to be, is it broadens the categories of workers that are protected, expands the definition of what in fact is retaliatory action. It provides employers with certain notification requirements of the statute, and as well as lengthens the statute of limitations period for how long a period of time employees do have the ability to bring a claim, and adds additional remedies for employees to pursue, and other avenues for them to bring these, whether it's jury trial and the like. So again, there's a host of amendments, and we're going to start going over those with the next slide. And with that, I'm going to turn it over to Victoria.
Great. Thanks, Howie. Appreciate it. Thank you all for joining us. I hope you can hear me well. So today is the end of the whistleblower law that we know it. So through today, the whistleblower law applies to private sector employers from retaliating against current employees who disclose or threaten to disclose practices that actually constitute a substantial and specific danger to the public health or safety. So now here we have underlined a few key items that are going to change with this new law that is in place. Also, the definition of retaliation is changing. So through today, retaliation includes discharge, suspension, demotion, and other adverse employment actions. And courts in reviewing this law and applying this law have required proof of an actual violation of the law by the employer to afford whistleblower protection. So that means there would have had to have been an actual violation. Now we're about to completely change and turn the page and go to a different law, and with that, I'd like to change the slide. So starting tomorrow on January 26, 2022, the law will prohibit private sector employers from retaliating against both current and former employees and independent contractors for disclosing or threatening to disclose to supervisor or public body any conduct that they reasonably believe violates any law or rule or regulation, or any conduct that they reasonably believe constitutes a substantial and specific danger to the public health or safety. There's a lot packed right in there. And like I did with the previous slide, we underlined some of the key language that is changed and that has different meaning than it previously did. So here we just have a big picture of what this law is. So let's start with some of the definitions. Who's regulated? So the employer, the definition of employer. The definition of employer has not changed. So employer still means any person, firm, partnership, institution, corporation, or association that employs one or more employees. So virtually every employer in the state of New York. What has changed is the definition of employee. Covered workers will now include both former and current employees. This is a change from the previous law, which only applied to current employees. So now former employees have a right under this law. And most significantly, employee isn't just defined by people who are actually in fact employees. They now include independent contractors. So independent contractors can bring litigation under this law and are protected under this law. Next slide, please. So one of the most significant amendments to the law is what constitutes a protected activity. The law continues to provide three types of protected activities, but the biggest change occurs for the first one. Later, Amanda will talk about the other two protected activities, but most significantly, there's been changes to the first type of protected activity. And this is the disclosing or threat to disclose an activity, policy, or practice of an employer that the employee reasonably believes is in violation of a law, rule, or regulation, or the employee reasonably believes poses a substantial and specific danger to the public health or safety. You may recall that on our previous slide, we talked about how the law currently, as it is, requires an actual violation of a law for there to be protection. This is a whole new wave of a change where an employee only has to have a reasonable belief that there is a violation or that there is a substantial and specific danger to the public health. So this new language significantly broadens how this law will be read and applied and to what activities it can apply to. And this is even more important in this day and age when we're still living in a pandemic. It's presumed that employees who report that they reasonably believe that there are violations of any laws related to COVID-19 regulations, that this reasonable belief and report of that reasonable belief will be protected under this law. So there's a very broad range of what we can expect to be protected. Now that we have an idea of what an employee needs to do, we need to know to whom they need to report. So the law provides that an employee can report to a supervisor or to a public body in order to be protected under this law. Now, there are caveats with both. Well, first, the supervisor. The definition of supervisor is unchanged. A supervisor is still an individual within an employer's organization who has the authority to direct and control the work performance of an affected employee, or an individual with the employer who has managerial authority. Now, public body has been greatly expanded. So not only the definition, but the application of what a public body is. So the definition of a public body has been expanded. It still includes government agencies that you would expect it to, and it includes government bodies that you'd expect it to, such as U.S. Congress, a state legislature, an elected local governmental body, any federal, state, or local government, a prosecutor's office, the police. So those are just to name a few. And that's what was in the original writing of this law. However, starting tomorrow, it also includes federal, state, and local departments of the executive branch of government, and any division, board, office, committee, or commission of any of the public bodies that have already been included in this law. So as you can see, this law is written to capture any individual who works at any of these government agencies who receives a report from an employee, whether former or current or an independent contractor, regarding a report of a threat of an activity or policy or activity that's in violation of the law or poses substantial health and danger, public health and safety danger. So that wasn't enough for the expansion to occur. This law was expanded even more regarding public body. So as I mentioned, there's the requirement that an individual report to a supervisor or public body. The report to a public body, though, is required. There's the requirement to report to a public body, but the law only requires that the employees make good faith effort to notify the employer in advance of making that report to a public body. So it's a very loose standard. We're making a good faith effort to notify an employee before actually going to a public body. And this is different from before with the law that is in place until the end of today, which you had to have notified an employer before in order to be protected by this law. However, this employer notification, this good faith attempt to notify, is not required in 5 situations. We have them here listed, but I'll briefly list them. So there's no such effort, no such good faith effort is required if there is an imminent and serious danger to the public safety or health. The employee reasonably believes that reporting to the supervisor would result in the destruction of evidence or other concealment of the activities, policy, or practice. Such activity, policy, or practice could reasonably be expected to lead to endangering the welfare of a minor. The employee reasonably believes that reporting to the supervisor would result in physical harm to the employee or any other person. And last, the employee reasonably believes that the supervisor is already aware of the activity, policy, or practice and will not correct such activity, policy, or practice. These 5 situations, as we can expect, will be liberally construed and will likely be a reason for an employee not previously providing or making a good faith effort to their employer before they make that that report to a public body. All right, I'm going to move on to the next slide. So we're still talking about disclosing or threatening to disclose an activity, policy, or practice of an employee that an employee reasonably believes is in violation of a law, rule, or regulation. So what does that mean? What does law, rule, or regulation mean? This phrase has also been expanded. Its definition now includes executive orders and judicial and administrative decisions, rulings, or orders. So that's specific to this entire conversation that we just had related to the previous slide and to this first bullet point has related to that first protected activity. As I mentioned, there are 3 protected activities. We just covered the most significant one, the one that has been expanded the most. But I'm going to turn it over to Amanda, who's going to briefly discuss how the other protected activities apply and the other expansions of the law.
Thanks, Victoria. In addition to what Victoria has just discussed, there are 2 other protected activities that employers should be aware of. They include providing information to or testifying before any public body that is conducting an investigation, a hearing, or an inquiry into any such activity, policy, or practice. Victoria has already provided the details of the expansion of the definition of public body, and so now we're all quite aware that it's a fairly significant expansion. Additionally, protected activity includes objecting to or refusing to participate in the activity, policy, or practice at issue. Importantly, the definition of protected activity no longer requires action based on an actual violation of the law, but rather only that the employee reasonably believes that the activity, policy, or practice is in violation. So now the question becomes, what exactly is prohibited? So employers are prohibited from taking retaliatory action against employees who have engaged in protected activity. Now, a pretty critical part of this expansion of the expanded law means that the definition of retaliatory action has also been expanded and now prohibits a much broader range of conduct. So the older version of the definition of retaliatory conduct covered retaliatory action to discharge, suspend, or demote an employee or other adverse employment actions taken against an employee in the terms and conditions of employment. That definition has now been changed, and the updated definition is amended to include actual or threatened discharge, suspension, or demotion, or any other adverse action against an employee related to the terms and condition of their employment, action that would adversely impact a former employee's current or future employment, And finally, the actual or threatened contacting of immigration authorities or reporting the immigration status of employees or their family members. So as you can see, this is a pretty significant expansion. Importantly, the prohibition against retaliation applies regardless of whether or not the protected activity occurs within the scope of an employee's job duties. Now, this is a critical point, and we think that New York has adopted it kind of in direct reaction to some case law from around the country. Other courts have applied a job duties exception to whistleblower statutes. And so what that means is that they've ruled that employees who take action against a perceived violation are not protected if they do so in the scope of their duties. So, for example, some courts have held that somebody acting as, for example, a compliance officer or maybe an internal auditor who engages in protected activity by reporting a violation that they come across are not covered by whistleblower laws because they were simply fulfilling their job duties. And what seems to be a clear rebuttal of this line of reasoning, New York is now expressly providing that even those who act in the scope of their jobs are protected by the law. Next slide, please. So under the older version of the whistleblower law, employees were required to report any violations to an employer before they reported them to an outside body, which provided the employer the opportunity to address and correct the alleged violations. Now, the updated requirement will only require employees to make a good faith effort to notify their employees of the violation before making the disclosure to the public body. Victoria's kind of already run through what exceptions there are to this good faith requirement, but as she said before, it's, if there's an imminent danger to public safety, if there's a reasonable belief that the employer will destroy or conceal evidence of the violation, if there's a reasonable belief that the notification would endanger the welfare of a minor or result in physical harm to the employee or another person, or if there's a reasonable belief that the employer is already aware of the activity and will not correct it. So employers now must inform their employees of their rights under the revised law by posting a notice conspicuously in an easily accessible, well-lighted places customarily frequented by employees and applicants. We expected the New York Department of Labor to issue a model notice for employers before tomorrow, but to date have not yet been able to locate one. Additionally, the statute of limitations has been expanded from 1 year to 2 years, and there are expanded remedies as well. So employees who have been the victims of such retaliatory action as described above may bring a civil suit and are entitled to a jury trial. In addition, the remedies for these violations include an injunction to restrain any continued violations, reinstatement for that employee, or in lieu of that, front pay, compensation for lost wages and or benefits, costs, attorney's fees, and punitive damages for willful, malicious, or wanton violations. And further, a court may impose a civil penalty of up to $10,000. So there have been some pretty significant expansions to the New York whistleblower law. Next slide, please. Okay, so in addition to the whistleblower law protections that have just been discussed, New York provides other protections for whistleblowers. In addition to the general retaliation protections kind of found throughout New York law, there's a specific protection for not-for-profit corporations that can be found on the next slide. Thank you. So in 2013, not-for-profit corporation law section 715B required required entities with 20 or more employees and over $1 million in revenue in the previous fiscal year to have a whistleblower policy. Technically, this requirement only applies to these relatively large entities, but smaller nonprofits would do well to and have adopted whistleblower policies in the wake of this law as well. There are a handful of exceptions that exempt certain entities from complying with the policy. The first being that if an entity already has a whistleblower policy that is in substantial compliance in place with the law, they are not required to change it, so to speak. And the definition of what the law requires, and so what entities need to be in substantial compliance, will be discussed momentarily. The other exceptions include if it is a state authority or local authority under New York's Public Authorities Law, if its board members already have established written policies and procedures that protect employees from retaliation for disclosing information about misconduct, and finally, if the organization is prohibited by the Public Authorities Law from taking adverse actions against the whistleblower. If a covered entity does not fit either of these two exceptions, then it must revise its existing policies to get into compliance, or adopt a policy that complies with the requirements that I'm about to discuss on the next slide. So a policy under the nonprofit law has to include several things. So similarly to the whistleblower law that we just discussed, these policies also include a good faith exception. So they need to include procedures for reporting violations or suspected violations, including those that are made in good faith. Those procedures should address specifically who the violations should be reported to, possible means for reporting, the investigative steps that will be taken, consequences for the violation of the policies that are designed to protect against retaliation, and other procedures that the entity deems appropriate. Importantly, there needs to be an option for anonymous reporting. Additionally, the policy must designate one or more employees, officers, trustees, or directors to administer the policy. That designated person is then required to report on the policy's implementation, the general type of complaints that have been received, and the resolution of whistleblower complaints to the board or any other committee designated by the board to hear these complaints. Additionally, it must include appropriate protections for retaliation for those who report activity that is illegal, fraudulent, or in violation of the adopted policy of that entity. So this requirement, there is a requirement that the person who is subject to the whistleblower complaint not be present at or participate in the board or whatever committee deliberations there are about the underlying complaint, or vote on the matter relating to the complaint, which, makes some sense. However, there's nothing in the law that provides for a prohibition on the board or the committee requesting that the person who is subject to the complaint provide information for background or answer specific questions at a committee meeting or a board meeting before the commencement of any sort of voting or deliberation process. And finally, there's a requirement that the policy be provided to all directors, officers, key persons, employees, and volunteers. And with that, I think there are some additional federal whistleblower protections that Victoria is now going to discuss.
Thanks, Amanda. Okay, great. So we're going to now briefly discuss the federal protections. So as you've gathered by now, the New York whistleblower law starting tomorrow is now extremely expansive. But we want to remind you that there are also federal whistleblower laws, and there are agencies that enforce whistleblower and anti-retaliation laws. Here are the 5 agencies. There's OSHA, the Mine Safety and Health Administration, the Office of Federal Contract Compliance Programs, Wage and Hour Division from DOL, and the Veterans Employment and Training Service. So they all regulate and enforce whistleblower and anti-retaliation laws for different subsets of employees and different groups of individuals. We're not going to go too deep into those today, but we just want these to be in your mind as well, because though our focus is on the New York whistleblower law, we must also remember that there are federal protections as well. Next slide, please. And often, when there's a discussion regarding whistleblower protections, the Dodd-Frank Act often comes to mind. So Dodd-Frank expanded whistleblower protections and brought in prohibitions against retaliation. And to qualify, though, for protection under the anti-retaliation provision of Dodd-Frank, a whistleblower must demonstrate that he or she reported a potential securities law violation to the SEC. So they must actually make that report. The individual is required to report this information about possible securities laws violations to the SEC in writing before experiencing any retaliation. So there must be that writing before retaliatory action occurs. This means that reporting internally alone does not afford protection under Dodd-Frank. Well, this is unlike, as we've just discussed, with the New York whistleblower law that is going to start tomorrow. Now, interesting about Dodd-Frank, there was a circle split for many years about whether or not reporting internally provided protection, whether or not you had to do so in writing to the SEC. Well, in 2018, the Supreme Court came out and held in a decision that, in fact, internal reporting is not sufficient, that there needs to be this writing to the SEC. And then after about a year and a half after that, in 2020, the SEC adopted amendments and regulation to make clear that there has to be that in writing to the SEC and internal reporting is insufficient. So that's how Dodd-Frank is different in many ways, but particularly applicable here, where under the New York whistleblower, an individual can report internally and be protected under the New York whistleblower law. Next slide, please. All right, we're going to discuss some examples of whistleblowing activity. I'm going to turn it over to Howie to start us off.
Thanks, Victoria. So, we want to discuss, and you'll see all these case citations in this slide are from New Jersey cases, again, kind of borrowing from the SEPA and how these cases are litigated. And again, this statute in New York now does mirror SEPA in a lot of ways. There are some differences. But, these are some of these, these bolded bullet points or some of the key considerations, when litigating and defending employers in these type of cases that come up. And, things that, you may not need to address in the short term, but things to keep in mind, especially if you start to get, whether it's internal complaints or as these cases start to get filed. I mean, we've seen a lot of plaintiffs' counsels in New York, start to post on social media about this law, and just speaking with them as well. This is something that, has everyone's attention. So these issues are going to get flushed out. And again, are issues that have been the cause of a lot of litigation, back and forth in New Jersey. So we expect that to be the case in New York as well. So, in terms of how broad the law that an employee can rely upon, the New York statute, as Victoria went over at the beginning, spells out in a bit more detail, what can be relied upon in terms of legislation, judicial rulings, administrative rules, regulations, and the like. But, there's a catch-all provision, and, kind of the issue is what's going to be considered, the law that an employee can rely upon to base a whistleblower claim. So for instance, in certain instances, professional codes of conduct, of ethics, could be deemed a public policy. So in the medical field, accounting field, legal field, their professional code of ethics, which, could be deemed, and there's been litigation about this in other states, is that sufficient to be considered a law that can support a whistleblower activity? But the overarching theme is that, the dispute or the alleged law that, the employee is claiming or ordinance that has been breached, must really have public ramifications. If it's a dispute between an employer and employee, specific just between them, that's more of a private agreement, and that's not something that could form the basis of a claim, we believe, under the new statute. So Hitzman is a case in New Jersey. We cite to it here. That's viewed as one of the cases kind of spelling this out in a bit more detail, where there was a registered nurse who filed a complaint regarding the rate of infectious diseases among patients and reported the concerns to various governmental agencies, the press, the television, the TV, and ultimately was, let go. And the question was this person protected? And the New Jersey Supreme Court held that this person wasn't protected because although the professional code of ethics governing an employer's activities may constitute authority, for purposes of the New Jersey SEPA, here this was more codes or the employer handbook and patient guidelines and the like, which were not laws, therefore was not sufficient to state, a whistleblower case. So before I gonna go over to the next one, I don't know if any of our other panelists want to chime in on this particular bullet point in terms of, the issue of the broad nature of what laws can be viewed and be that hook for us for a whistleblower claim.
I know, Howie, thanks for that summary of that case. I think what's interesting about that case, as you pointed out, the concept of what the law is for purposes of these whistleblower statutes is very broad. But in that case, and cases like it, where there's somebody complaining internally about a employee violating a handbook, an employee violating some other sort of let's call it internal standard, those typically will not be whistleblowing activities, at least the way that the New Jersey courts have interpreted. And we rely on the New Jersey courts only because we've had judicial officers making these decisions, so it does give us a little bit of insight. But things like that, or I think there was another case where there was internal reporting, or somebody complained to a manager that somebody wasn't complying with like workplace rules, and those things, even though arguably they're important to those individuals that are at that work site, did not really constitute whistleblowing activity. So while I think the law is very broad, it does have some limitations, maybe not broad limitations, but a little bit.
Yeah, and I think the statute as drafted, spells out in a bit more detail, than SEPA does. So I think it puts a little bit more, just based on the language, some parameters around it. But again, it's one of those things that we're going to see and likely see. There would be cases where it's clear, what the law or the hook is that the employee is relying upon, versus others where I think it'll be an issue about whether or not it actually is a law or a regulation or something that's been recognized by the legislature in drafting this, versus something that's doesn't reach that level and therefore can't form the basis for a valid claim. Okay. Another issue that gets litigated quite frequently is, a reasonable belief in terms of, the employee or the independent contractor, again, because that's a big change here, is that it's not just for employees, it's for contractors. And I know this is something that a lot of clients I've been working with are kind of concerned about in terms of how to notify contractors, or does this change, or should they, how they should react to this. But in terms of that reasonable belief prong, likely it will have to be deemed as an objectively reasonable belief. That's the standard for SEPA claims, in terms of that you have an objectively reasonable belief that a law has been violated, not just my subjective or the employee or the contractor's subjective belief that, hey, this is violating the law. So, again, under SEPA, courts usually engage in a two-part inquiry to determine if an employee had an objectively reasonable belief. First, they look at what the law was or the regulation that the employee believed was violated or would be violated, and then determine as a matter of law whether the belief was in fact objectively reasonable, and whether there was a substantial nexus between the complaint of conduct and the specific law. If there is, then the belief is said to be objectively reasonable. The Dwarvener Case is again one of the seminal cases in New Jersey, where an individual complained that their employer, their executive board, wasn't accurately recording certain meeting minutes, and that violated the Labor Management Reporting and Disclosure Act, and blew the whistle, proverbial whistle, on her employer. And the court held that that person did not, in fact, have an objectively reasonable belief that the complaint of conduct, which was not accurately recording meeting minutes, violated some law. The reason being that the laws that she was citing had nothing to do with, note-taking based on meeting minutes. It had to do with denying certain people the right to attend meetings. So while yes, the employer may not have been accurately or taking notes, her hook was alleged violations of this Labor Management Reporting and Disclosure Act, and that law required or prevented employers from prohibiting entry to meetings by certain individuals and not others. And here, not having accurate notes, the court held there was not an objectively reasonable belief of this employee that the conduct she was complaining about violated the law, because the law, what she was complaining about had nothing to do with denying individuals the right to attend meetings. It was that notes of the meeting that people were not excluded from were not accurate. So again, it's just, you'll see, and we see a lot of these cases, there's just, in the complaint, there'll be some reference to a law and that this conduct violated it, but it's really not just an automatic, go issue. You really have to see whether it's an objectively reasonable belief that the employee who's filed it or the contractor had that the specific conduct they're complaining about violated some law. And again, there's a host of cases that deal with it, and it's something that we anticipate, being a hotly litigated issue as well once the statute goes into effect tomorrow. Anyone else?
I think that's,
yeah, sure.
Yeah, Howie, I think that's absolutely right. I think this will be a very hotly litigated issue, because the question will be the reasonable belief of the rank and file employees. A lot of times this is going to really be a question of the reasonableness of somebody's sort of belief in what the law is, which law was triggered, what the conduct was. And while these tests exist to help guide the judicial, decision making, the unfortunate reality of it is that there's going to be a lot of debate, I think, about this going forward, at least in the first couple of years of the statute, as to where that reasonableness line is drawn and how that's interpreted. So what are we really dealing with? I mean, we're not really going to be dealing with a bunch of lawyers debating what the law is. We're going to be dealing with employees who are, boots on the ground at the work site, and what their impression is of what the law applies, what their impression is of what the conduct is, whether it violates it, their impression of how this all shakes out. And from a practical standpoint, although we're looking at this from an objective standpoint in litigation down the line a couple of years, the day of when these things are happening, and as these things are contested in the front stages, in the early stages of these types of complaints, I think these will be not just hotly debated at the work site and not at the time. I think that this will take a little bit of litigation to really ferret out and shape the case law in New York. So I think that is a key element of this law that we need to pay attention to.
Definitely.
So let's take a quick review of Watchdog employees. So the terminology of Watchdog employee actually borrows from case law that developed in New Jersey. It's actually from the appellate division in New Jersey that characterized the definition of what the Watchdog employee really is someone whose job it is to either know or secure compliance with a relevant standard of care, or knowing when an employer's actions or proposed actions deviate from that standard of care. So effectively, to kind of translate that, that's basically your compliance officer, your safety officer, somebody who you hire to keep the company in line with whether it's a standard of care, a safety regulation, or something along those lines. Those employees, when as part of their regular course of their job responsibilities, run into issues and report those issues, whether it's up within the chain of command, whether it's some other sort of reporting internally. Those are the situations that are characterized as Watchdog employees. To some extent, I think the term is a little out of date in a way, because that was really moved away from by courts eventually, but it does provide a neat shorthand. And I think the situation in that Lippman case that's cited really bears a little bit of discussion to see how this plays out in real life. Dr. Lippman was someone who worked at a pharmaceutical company, who was on effectively a safety and compliance board, reviewing proposed medical devices and pharmaceuticals, whether it was prior to them going to the market or after they had gone to market, and raising certain whether it was safety implications or concerns and keeping that on an ongoing basis, keeping a finger on the pulse of what was going on with those devices. During the course of his career, he had expressed a lot of opinions that were positive and negative, and a lot of times the negative opinions of the devices, whether they called for recalls or adjustments to various things, were followed by the company. He and the other board members did this on a regular basis. What's interesting about that situation, though, is he was actually terminated for having a inappropriate workplace romantic relationship, but turned around to say, actually, my termination wasn't really about any of that stuff. It was about the fact that I've been saying all along, we can't have, XYZ product or XYZ device or XYZ pharmaceutical on the market, and we need to recall it. And, the company was so profit driven and profit focused that it decided to retaliate against me for all those times that I complained about their products. What's interesting is that that issue of whether a person in that role was a whistleblower was probably litigated for a good 7-8 years, with the trial and appellate courts siding with the companies that basically the reason they hired specifically to ensure the company's compliance and did exactly what they were supposed to do, acting within the scope of their job duties, was not really going above and beyond and objecting to anything that was going on. What's interesting is that there was a prior case of a coffee shop manager that had been litigated a couple of years before, and she had raised internally to her supervisor. She was a district manager. She had gone to stores within her district and found that there were the thermometers that were in their cooling units were broken and they had to be replaced. And technically, those retail establishments were out of compliance with various food safety laws or regulations. She had reported that at this retail establishment, they were having overnight sex parties. She was reporting that there was product that was missing and unaccounted for and effectively being stolen. She actually even went so far as to go to the local police department and report some of the theft that was going on. Ultimately, her employment was terminated because of a lot of negative feedback that she had received from her subordinates as far as her demeanor and the way that she treated staff and customers. But she turned around and sued as a whistleblower, and the appellate division in that case wound up finding that all of her complaints were within her job responsibilities and therefore not really protected whistleblowing activity. And later on, when the issue was presented to the New Jersey Supreme Court, the defense made an argument basically saying the definition of the law calls for an objection. So if you're doing your own job responsibilities, how can you be objecting? And in the case of that pharmaceutical compliance officer, the person was specifically charged with bringing up safety issues, made such reports, and they were followed by the company. Where was the objection to what the company was doing or the legal violation for what the company was doing? And in that case, the New Jersey Supreme Court kind of looked at that and said, despite the fact that it was that person's job responsibility, they raised they raised a complaint or an objection to something that was going on that they reasonably believed was unlawful, that there was no clause within that statute that had engrafted an additional requirement that it not be within a person's responsibilities. In New York, on the other hand, as of tomorrow, the law is going to say that it's irrelevant whether it's part of the person's responsibilities, that even if you hire a safety officer, somebody to monitor your food safety, monitor your legal compliance, COVID is certainly a reality, and how that is carried out. Any employee that is within their job responsibility to ensure compliance and raise those issues is likely to be a protected whistleblower. I'd love to hear if any of the other panelists have any further thoughts about that.
No, I think that is always, when, someone's job responsibility and, what level of, protections they're afforded if it's part of their doing their job. That is always something in these whistleblower cases that, kind of boils down to, it's a tricky situation, but I think here there is a difference in terms of how the New York statute's written that, may be more expansive than some of the other laws, in terms of trying to defend the case based on someone's responsibilities.
I think you're exactly right, and I think that was not unintentional. I think the legislature saw the fight that had happened across the river for close to a decade and closed that loophole before it ever came to exist. Let's move on to another topic quickly, sort of along the same lines. What about in-house attorneys? Interestingly enough, the case law in New York relating to attorney "quote unquote" whistleblower conduct is interesting in that it primarily deals with the law firm context. And in the law firm context, interestingly enough, the New York Court of Appeals was very quick to dismiss the fact that Labor Law 740 applied, saying, "Of course, it doesn't apply. That's not a thing here." At the time, this was about 10 years ago or so. What's interesting is that in the law firm context, the Court of Appeals has long held that part of employing an attorney implies that they're going to comply with their ethical obligations, and the firm is going to comply with its ethical obligations. So if an attorney is objecting to conduct within the law firm, for example, in one situation, there was an attorney within a law firm that had effectively been assigned internally an associate to work on his personal condominium transaction, and that associate dropped the ball, and eventually it came out that the associate was engaged in effectively malpractice and being very negligent. At the time, the New York ethics rules made it mandatory that had to be reported to the ethics authorities. The law firm had resisted. The plaintiff in the case insisted that they do the reporting, and eventually that attorney was fired. The plaintiff was fired. It coincided timing-wise with some other activities in the case that made it suggestive of retaliation. And the Court of Appeals effectively said that in those types of instances where there is a clear requirement under the rules of professional conduct, and it's in the law firm context, it would be protected, even though there was no statutory basis or common law basis for that, other than when the Court of Appearance had so found. Interestingly, with in-house attorneys, we have two cases referenced from other jurisdictions here, the Third Circuit and the New Jersey Appellate Division. And in those cases, it dealt with in-house attorneys and what in-house attorneys had either done or engaged in, and whether that constituted whistleblowing activity. And in one case, the in-house attorney found that the business folks had effectively bought trade secrets through a back channel that had been involved in a competitor's litigation. The attorney raised concerns internally about that and objected to participating in that conduct, and was demoted shortly thereafter. The argument on the defense side effectively said that SEPA should not be used to meddle within the attorney-client relationship, and whether it's force attorneys to act a certain ways, or for in-house purposes, force a client to either engage or not engage an attorney, or how they manage that relationship. And the court basically had none of it. The court basically said that SEPA doesn't really have any exceptions for in-house counsel. We similarly don't expect this, especially with the language of it being within the employee's job responsibilities, to have any such carve-outs for in-house attorneys. In another case, there was a cosmetics company that had, the allegation was that they had a quota for how many patent applications they could file, and the in-house patent attorney basically said they would not meet their quota because they refused to file unsupported patent applications. In that situation too, the New Jersey whistleblower law was found to have certain protections rooted in, and interestingly, going back to the earlier conversation, what was the body of law that they relied upon was actually their ethical responsibilities, which on the federal level had been codified into federal regulations, and on the state level constituted such an expression of public policy that it effectively acted as the law that was being referenced. With that, before I turn it over to my next colleague, I would like to read the CLE code. So for CLE purposes, the code is SS 5477. Again, SS as in Seyfarth Shaw 5477. Thanks so much. Why don't we move over to the next case?
Great. Thanks, Rob. Appreciate it. Okay, so the next topic here is how might this impact employees who have limited contact with New York State? Now, this is going to be a hotly litigated issue, specifically because of the remote work environment that we are living in and that most employers are still using, either a hybrid or a 100% remote. Employees may be in New York State without their employer knowing that they're in New York State. And the employer may be a California employer, expecting that their employees are working remotely from California, when in fact the employee is visiting family and working many months or weeks in New York. So how is this law going to apply to those individuals? And a lot of what we considered here is how New York law has, other New York laws have considered remote work and limited contacts to New York State, but also we also looked here like to New Jersey law, but it still is going to be a wait and see process. Some of our initial thoughts here are that, of course, the Department of Labor will likely look to where the employee is primarily located, where the employee is domiciled. That will be a big part of whether or not an employee may be protected under this law. There is a case out of New Jersey that the individual was in New York. It's a SEPA case, but the individual was a New York employee, worked for a New York company, but went to New Jersey every so often, maybe once or twice a week. And the issue was whether or not SEPA was available to that individual. And so the court ended up finding that it did not, for the fact that there was such a limited purpose of that individual's employee going to New Jersey. But there's a lot unknown here of what we can expect, but we anticipate, based on how other New York laws have interpreted other laws, that there can be an expectation that we will err on the side of finding jurisdiction, and that even in some situations where there's limited contact with New York State, that individuals will be protected under the law. And we could talk about this for a while, but this is definitely an issue that's going to have to be played out. We'll see how the Department of Labor handles this, see if there's any FAQs that come out on this. We'll see how it happens in court. I don't know if Rob, Howie, or Amanda have anything else to say about this, but this is something that we're going to keep our ears out for.
I think that's right, Victor. I think ultimately a lot of these agencies and courts have generally always held that New York law will, apply within the state of New York, but in the state of virtual and remote work, the hooks into New York, can come from a variety of different sources. So it's interesting to see. It'll be interesting to see how this plays out in the courts.
Yeah, I tend to agree. I'm just gonna very quickly, because I see that we're running a bit short on time, discuss what constitutes retaliation. This has been an issue that New Jersey courts have been dealing with for years. And so some of these cases here, starting with Ayala's v. Ziza, have discussed retaliation, or more importantly, what's not retaliation. So to briefly summarize this case, the defendants here, the members of the Hackensack Police Department, were alleged to have engaged in some extortion and other unsavory behaviors. And the crux of the claim here was that a letter was sent to the chief of police, basically saying that there were threats against other officers, promotions were denied based on personal reasons, and importantly, that one officer was not a resident of the town when he applied for his position. Basically, the court kind of concluded that a mere disclosure of a past wrong was not sufficiently meaningful to qualify as an objection to an activity, policy, or practice. The court kind of focused a lot on the language indicating that the activity, even if it's not ongoing, was at least something that lasted more than an instant. So in this case, the time it took to file a job application, depending on where the employee lived. Additionally, it wasn't clear at the time that the application was filed that it was actually a rule or regulation that members of the department actually live in this jurisdiction, and so it wasn't clear on its face that this was a violation. So the court kind of summarized by saying that not all conduct should be considered retaliatory, and that retaliatory action means the discharge, suspension, or demotion of an employee or other adverse employment action taken against an employee in the terms and conditions of their employment. So, obviously New Jersey has decades worth of experience kind of litigating these cases and diving into them, but it'll be definitely very interesting to see what New York's take on retaliation and what the state does with the definition of these actions here, because they've had the opportunity to watch New Jersey kind of dive into these things and kind of see the outcomes from those cases. There are, I suppose, two other cases that I will very, very quickly touch on. The next one being Klein v. UMD&J, where a doctor there noted that there were some practices that he didn't agree with, and the court ultimately concluded that the practices that he did not agree with were not actually violations of law or policy or practice, and that SEPA is not intended to shield complainers who disagree with the manner in which a job is being conducted, provided that the conduction of that operation is within lawful and ethical mandates. So it'll definitely be something to see, especially considering that New York has this reasonable belief prong, to see what the New York courts do with this information. And then finally, Carp-Haver v. City of Trenton kind of discusses that retaliatory conduct, or let me rephrase rather, that actions that may be considered adverse, such as being reassigned to a different position, even if that reassignment is substantive, if supported by an underlying legitimate non-discriminatory reason, might not be sufficient to uphold a SEPA claim. And with that, I think we can move on to the next and final slide of employer considerations.
Perfect. Thank you so much, Amanda. So the first consideration for employers is management training, frontline managers. What happens when these situations actually arise in those first instances when an employee raises a complaint to a supervisor, says, no, I'm not going to do that, I think that's against the law, or no, I'm not going to do that, I think that's wrong. When those situations come up, those are oftentimes make it or break it situations, whether or not there may be a whistleblower activity, and whether or not what the response is, as far as whether it's not retaliatory or arguably retaliatory or not. If these complaints get funneled into a investigation system or something like that for a lot of employers probably already exists in the discrimination context, that can be fleshed out. But those initial stages for frontline managers, I think, are going to be critical for employers to be mindful of.
Great, thanks for that, Rob. A New York employer should also revisit their whistleblower and compliance policies. So you should consider providing specific training to managers on how best to handle potential whistleblowing activity, as well as retaliation claims from whistleblowers. Definitely instruct your employees on how to approach these situations, and should also confirm that your existing policies and procedures are in compliance with this upcoming law. Finally, of course, you should keep an eye out for whenever the notice is posted, and make sure that once available, that notice is conspicuously posted somewhere in your establishment.
And then just briefly, providing your employees with additional channels for internal reporting. So letting employees know of the phone line they can call, the hotline, email address, providing them with names of individuals to whom they can report. Just letting employees know and giving them those resources will be very important.
All right. Thank you, everyone, for your time. We can go to the next slide, which I think is just our wrap up. We appreciate your time and patience today. Obviously, there's a lot of material here, and the model notice has not yet been posted, but we'll be sure to get out a client alert and be sure to follow up with all attendees who registered once that model notice has been posted so that everyone's a bit aware of it. And obviously, if you have any questions, let us know. And we did see that several questions came in, and as we promised, we'll be sure to get back to everyone who submitted those questions. So thank you, everyone, and have a great day.
All right. Thanks so much, everyone.